Okay, great. Uh, Let's go ahead and get started then. I'll call our meeting, the meeting of the State of Nevada Public Records Task Force to order. It's just past 1 o'clock on July 22nd. I'll go ahead and call the roll. Please just indicate with the here. Ben Lippman,
Here.
Brittany Walker,
Here.
Colleen McCarty,
Present.
Kaylee Work,
Here.
Leslie Nino Piro,
Here.
Mitch Fox,
Here.
Matt Morris,
Here.
Matt Christian,
Here.
and Stacy Lindberg.
Here.
And Josh Hicks, I'm here as well. So we have everybody here. Thank you. We'll go ahead and move through our agenda. We'll go to public comment. Starting up north in Carson City, is there anyone here who would like to make public comment? Not seeing anybody in Carson City. Is there anybody in Las Vegas who would like to make public comment? If so, please come up to the podium.
There's nobody coming up.
Okay. Is there anybody online who would like to make public comment? Please say something because I can't necessarily
If you
see
would
your
like-
screen.
Yes, if you'd like to participate in public comment, please press star 9 or raise hand in the Zoom window to take your place in the queue. Kathleen Light, you are unmuted and you may begin.
Ms. Light, go ahead with your comments, please. And please keep your comments to 3 minutes so we can keep moving. Thank you.
Absolutely. My name is Kathleen Light. I spoke at your last meeting about my sexual assault by a former state official. Today, I want to address the purpose of my public records request because DPS appears to assume it should decide which purposes count. DPS asked for special treatment of records involving criminal, administrative, intelligence, and threat assessment investigations. It asked for more fees, longer timelines, and a process for requests it considers extraordinarily burdensome. It also suggests treating requests differently when the agency believes they involve commercial use, social media content, or something other than the public interest. I know exactly what a threat assessment record can mean. I was placed under a counterterrorism investigation for alleged quote unquote indirect threats after saying I intended to attend campaign events. I was not planning violence. I was engaging in political discourse. When the government can classify political speech as threat, then conceal the records explaining how and why it did so, public records access is not a burden. It is the only meaningful check on government power. My records requests were not commercial. My purpose is not entertainment. My purpose is to understand why intimate partner sexual assault remains practically invisible to the systems supposedly designed to address it. CDC data shows that 1 in 5 women experience sexual assault by an intimate partner. These cases are misunderstood because the perpetrator remains embedded in the victim's life. The victim may stay, return, or struggle to disengage. The law formally recognizes that intimacy is not permanent consent, but institutions continue treating the relationship itself as evidence against the victim. The laws regarding intimate partner sexual assault were written for women like me. They say a relationship is not consent. They say love is not consent. They say no still means no. The problem is not the law on paper. The problem is whether victims can obtain the records, showing why government refused to enforce it. DPS should not be allowed to define accountability as a burden, then decide that the person seeking it does not serve the public interest. I represent 1 in 5 women who experience sexual assault by an intimate partner. My requests are not about profit. They are not about clicks. They're about accountability. If that does not serve the public interest, I would ask this task force one question. What does?
Thank you, Ms. Light. Any other online public comments?
If you have recently joined the call and would like to participate in public comment, please press raise hand in the Zoom window to take your place in the queue. There are no more callers wishing to participate at this time.
Thank you. I'll just note for the record too that we did receive some written public comment, and all the written public comment provided through yesterday has been disseminated to the members of the task force. So thank you to those who submitted that. We'll move on to item 3, approval of the June 8, 2026 meeting minutes. Does anyone have any comments or revisions to those meeting minutes? And if not, I'd be looking for a motion in a second.
This is Matt Morris. I would move to approve the minutes.
Thank you, Mr. Morris. We have a motion. Do we have a second?
This is Mitch Fox. I will second that.
Thank you, Mr. Fox. We have a motion and a second to approve the minutes from June 8, 2026. All in favor, please say aye.
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 Aye. Any opposed?
Aye.
Any opposed? Motion passes unanimously. Thank you. I will move on to agenda item 4, discussion of the presentation to the Joint Interim Standing Committee on Government Affairs on July 9th, 2026. I know Mr. Lippman and Ms. Work were there. I don't know if one of you wanted to take the lead and just give the task force a quick update on that presentation.
Sure, I can. It was fairly short and to the point. It was, Kaylee and I each gave them some idea of what we have been doing and what's yet ahead of us, most of which was covered in the written materials that we gave them that you all had seen ahead of time. And then there were a few questions focused on, I would say, whether we think we have enough time, what we think we might be able to accomplish. We had told them that we thought that the group thought that our task was rather ambitious, and we didn't know just how much of all of the things they had suggested were things for us to look at we would actually get to, but that we were doing the best we could, and we would be back to them in the end of October. Kaylee, is there anything else I missed or you'd like to add?
I think you covered it, Ben. I think we did hear from Assembly Member Nguyen that he was certainly interested in seeing best practices from other states. So if there is a way for us to work in some of those best practices into our report or maybe in the appendix, that might be something that this committee considers.
Thank you. Any questions or comments from members of the task force? Do we need to do a follow-up report to that joint committee?
I don't think that we do. I think, I'm sorry if I didn't hear that correctly. I think the October date still stands unless there was any other discussion from our task force needing any extensions or anything like that. I think, Ben, did you hear anything different about a different status update?
No, I did not. I didn't get the feeling that they were expecting anything between now and our final report.
Okay, great, thank you. Seeing no other questions or comments on that, we'll move on through our agenda. Item 5 is to review the draft report template. We do not have any presentations today, unlike our prior meetings, so This will be more of an open forum, I think, for committee members to start going through the template, start having some discussions on how we want the ultimate report from this task force to come out. So with that said, I think everybody has a copy of the template that's been circulated previously. I'll open it up. I don't know if anybody had a particular place or comment they wanted to start, but let's start with an open forum and see if we can have some discussions on some sections. We can also go through it kind of section by section too, if the task force would like to do that.
Mr. Chair, if I could be recognized for one moment, please.
Yes, please go ahead.
Colleen McCarty for the record. I just sent everyone a copy of the suggested revisions, additions to the final template report that the transparency advocates put together. Also distributed hard copies to the folks who are present here on the committee, just so everyone knows it's available in their email.
Leslie Nino Piero for the record. Colleen, are there additional copies that are available for members of the public if we're to consider any of this? I believe it has to be made available to the public contemporaneously.
Yeah, we've got, Matt's got extra copies there. I have extra copies here.
Okay.
Okay, does everyone have a have that email from Ms. McCarty?
This is Stacy. I did not receive it.
My apologies, Stacy. I think I missed your email address. 1 second.
Okay, thank you.
This is Mitch Fox. I just received Colleen's email with the template. I'm just reviewing it now.
This is Brittany Walker, and likewise.
This is Kaylee Work, and my email's just taken a moment to load, so I'm sure I'll get to you in just a moment. Thank you.
Stacy, it's headed your way.
Proceed. Thank you. I'll take a look.
Okay, I think now everybody has received it. This is the template, like Ms. McCarty said. It did have some comments from some of the transparency members on it. This is very much a working draft that's subject to revision, as it notes on there. But it's just to give us a guideline and a template to kind of work through where we are. So I think we could probably start with some of the comments. I know Ms. McCarty, Mr. Lippman, you had some early on. I know I had some in there as well. I'm not sure what the most efficient way is, but perhaps we just start with where the first comments were, which is on the second page, 1.2 objectives. So I don't know if Mr. Lippman or Ms. McCarty, if either of you wanted to take the lead there on making any comments about some of those.
I don't think we had anything to add in that section. I think the first comments started really in 3.1, and the first one there talks about looking at whether there are exemptions that should be removed. If there's anything in there that's no longer accurate, no longer active, or redundant in any way. There had been some discussion among the transparency advocates of trying, and I think that's on here somewhere, of trying to put together a more efficient list of the exemptions that the public could understand easily. So some sort of a document that would take each statute and provide a brief description of what it is, so that they're just not numbers. And I think in that process, we're contemplating trying to see if there were any that needed to come out as well.
Thank you. So I suppose for this section, we're not talking about specific exemptions to be removed, just the concept of reviewing them and evaluating whether some should be removed.
Correct. And this would not be, trying to redo the law. It would just be if there was anything in there that, is obviously should no longer be there because it's outdated or no longer operative.
Okay. My thought is that we don't maybe necessarily line by line decide these, but just maybe have a discussion about them and see where there's some consensus on what should be in and what shouldn't be what should be out. But I guess I'd just ask generally, does anyone have a concern about identifying exemptions that would be subject to removal?
This is Brittany Walker. I would just say that there's I think hundreds of statutes listed there. And if someone wants to go through and list those and what they are, that would be helpful. Or I'm sure that list exists somewhere. I'm sure one of the local government entities have created that, but there's so many, and when they apply, when they don't apply, requires going to different chapters of NRS, and I just don't know that it will be in our scope to go through all of them. I think that would be very time consuming. I agree with identifying some that should be removed, identifying some that should be added even, or that we believe are in existing law, because it cites those statutes, but it also says, and anything else declared by law to be confidential. So in my experience, there's been some areas of statutes where there's confidentiality there, but it's not listed. So I just don't know if we'll be able to be exhaustive, I guess is my comment.
Chair Hicks, this is Ben Lippman. May I be recognized?
Yeah, please go ahead and just go ahead and speak. You don't need to ask me to bless it.
Brittany, in response to your request, I'm happy to put together something that lists all of them. I think there are listed in that statute, then I think the number is 597 that have been listed, which of course is a rather ridiculously long list, but we can put together that list and then start looking at which of them it might make sense to take out when you have that many. Of course, just because it's listed there doesn't mean that there's actually a restriction in it. There are, I think the vast majority of them do have it, but we'd have to look at them to see if the statute referenced really does restrict access to any records, or perhaps it's just some sort of timing restriction or whatever it might be that exempts it from one part of the Public Records Act or the other. But I am happy to try and put together that list that gives reference to what it is so we can start looking through it. And I think it would behoove us to take a look at whether in all of that, how much of it is overkill or superfluous or repetitive or just not something we think should be in there.
This is Matt Christian. I believe that I already have a spreadsheet that lists each one of the statutes and then copies the title of the chapter or the title of the statutory provision. I'm not sure if it's fully updated, but it would be a pretty good start because I know the last time I saw it, it was very long. So maybe I can provide that to Ben and that'll be a good start.
That'd be great.
Leslie Nino Piero for the record. My office also has a working spreadsheet. So hopefully between those two drafts, I still need to go through it and just, it's been a work in progress over the summer in our office. So, but at least there's two spreadsheets to start from.
Thank you. I love volunteering for work that's already mostly done.
It sounds like we may have just formed a subcommittee to review exemptions.
Subcommittees still have to meet under open meeting law if they're formally appointed subcommittees.
I was saying that informally. But if the three of you can compare those lists or provide them to the task force, I think that'd be a great start.
I think clarifying the exemptions and adding a few may be a very good idea. So I'm very interested in seeing those spreadsheets as well. So thank you guys.
And this is Matt Morris. I think too, just to note, it's definitely a topic that should be in the final report. It's the first thing that AB 128 called out. So I definitely agree that we should take our best shot at trying to tackle that.
Great. Then it sounds like maybe at a future meeting we'll have an actual list to go through and make some comments on. Does that sound like a plan?
Sure.
Works for me.
Okay. I guess moving on down the template, section 3.2 is policies relating to review boards. Again, these are just kind of our topical areas to look into. Did anyone have comments or thoughts or revisions to that section?
This is Matt Christian. I don't have any revisions to that section, but I would maybe just note that I had originally planned on having a member of the Las Vegas Police Protective Association come and speak to us about this particular topic. We were going to do that in June, and then we decided to wait. So I can still arrange for that. This is a very specific topic. It's probably the most specific that's identified in the bill. I know a little bit about it, but it's very specific, I think, only to Las Vegas Metro Police because we are the only ones that have a review board. And there's litigation pending over these statutes. So by the Las Vegas Police Protective Association. So I would just offer up the presentation again. He can come in August. I think it would only take 5 or 10 minutes. And he would give us just a quick overview of what these statutes are and how they're operating in real life. And then we would be better informed.
Makes sense to me.
Okay, thank you for that, Mr. Christian. Any other comments on section 3.2? Seeing none, we can take a look at 3.3, impact of broad public records requests. I know this has been an area of concern for the governmental representatives. So, and I know there is a couple of revisions that are added onto this. So I'll open that up to anyone who wanted to comment on this or comment on the suggested revisions.
This is Leslie Nino.
What does it mean? Oh,
Go ahead, Brittany.
Leslie. I just had a question about the additions for the individuals who added them. What does identify value of such requests and value of the information sought mean?
I think it means the value to the public of having access to the public records.
Is there this is Leslie Nino Piero. Is there a specific methodology that maybe we can to try to wrap our heads around this, a methodology for valuing value to the public?
You mean, do we have a number to quantify the?
Like, how do you go about the methodology in placing a value on the what would be available to the public?
How do you place a value on public access to governmental records
Right,
in general?
right.
Well, I guess the legislature has by saying how important it is
Right,
to our
but
democracy.
We're talking about, so we already know that it's a top line value in the MPRA, but so is this asking for a dollar amount that we're putting on
No,
the information? So this is more of just kind of a policy preference, like restating the policy preference in the MPRA?
I don't think it's a mere restatement, but I think it's important if we're going to be talking, if we're going to have the government people talking about why they think they shouldn't have to provide public records, I think we should also talk about why public records should be provided.
Okay, that's the clarification I was looking for, was whether or not we were talking about a dollar amount.
No,
Okay.
I'd already said that.
Thank
you. This is Brittany Walker. I see Stacy's hand raised. I don't, I just wanted to say that I think the sentiment here on the identifying the value is well meant. I just think it's out of place for this section, because this section isn't contemplating that records requests aren't valuable. This section is contemplating that broad requests that aren't specific and are sort of a scattershot burden and bog down local government entities. And there has to be an analysis of how those broad, non-specific records requests impact us. And so I don't see, like, because the issue is not that they're not valuable, it's just that we get requesters that say, we want all emails related to this topic. And that can yield thousands, tens of thousands. And when really the requester just wants like one email. And so anyway, I don't know if the chair, would you like to recognize Ms. Lindberg? I think she has something to add.
Yeah, Ms. Lindberg, if you're trying to speak, please go ahead.
Yes, I am. I just had a couple comments, and just like reading some of the public comments that came in and listening to the public comment on the lady that, you know, had issues trying to get information about her specific case. I just think a lot of times these public requests, many cases, I mean, they're like human nature it appeals dramatic or sensational content can outweigh the genuine goal of the government accountability in public records requests. Too often the focus shifts from examining official conducts to consuming compelling footage or personal details that do little to advance transparency. I am reading this because it's very important for me to get my point across on this, because I believe victims and individuals accused of a crime should have prompt, no-cost access to records and files related to their own cases. They have a direct personal interest in the information and should not face financial barriers or unnecessary delays in it. However, I also believe they have a meaningful voice in whether records, particularly videos or other sensitive materials, are publicly released. While transparency in government is important, the privacy and dignity of the individual must directly affect, should be carefully considered before those materials are publicized. And that brings me to my final comment. I believe public record laws should continue to promote transparency, but requests made for commercial or profit-generating purposes should not impose an unfunded burden on our taxpayer. When a requester, including a media organization or other commercial entity, seeks public records for profit purposes, I believe the requesting party should reimburse the agency for actual costs of fulfilling the request, including reasonable staff time billed at an hourly rate. This approach helps ensure the cost of extensive records requests are borne by those who benefit commercially from them, rather than by the public agency and the taxpayer it serves. So after saying that, I really feel it is important to get a balance. We talk a lot about public, government transparency. You know what? I mean, to the private individual that's paying their taxes and supporting our government, absolutely. It shouldn't even be a thought of whether they deserve that information. But when it's used, in for-profit or for publicizing or sensationalism, they need to pay for those records. And I think that's where a lot of this issue arises, is from like our sheriff's departments and our courts and things like that. Those are affecting people's lives. And I just don't see where those are public records and keeping, we hold the service, the person working for the government accountable. We shouldn't be, if it's not directly affecting that government official, why would it be a public record? That's all I have. Thank you.
Kaylee Work for the record. I just want to go back to a comment that Brittany made about section 3.3 about identifying value. Ben, I think this was your comment, and I think this part is really important. I also think that each of us all agree that there is a big value for the public to have access. Of course, this is already in the law. We've already the evaluations, the presentations we've heard, our own experiences, we know there's obviously a big problem with public records, and we were tasked to, hear out these issues, which I do think our evaluations belong in section 3. I think AB 128 could have gone a lot further, what I'm finding out with just these findings and evaluation areas. I think this could have been a longer list than it currently is. I think probably some of those identifying value, I think we can put some of those, maybe it might make more sense in section 3.5. I know it's more of a financial burden on requesters, but perhaps I would be open to, maybe identifying some of that in section 3.5 instead. I just think it maybe fits a little bit better. So that's something for the committee to think about. But also, I know we're getting into solutions, and I think section 4 is really where our solutions and our recommendations will really come into play. So I don't want to exhaust kind of our findings too much. I don't think this is going to be the meatiest part of our report. I think section 4 will be the section where we really list our solutions and recommendations for the legislature.
Leslie Nato Puro for the record. Piggybacking on Kaylee's suggestion, if I think it may also be appropriate to talk about the value in the overview, because it is a stated principle already within the MPRA. So either section 2.2 or 2.3, so that it's more of a top line applying to everything that we are looking at within our review, rather than as Kaylee kind of reiterated, the section 3.3 that is directly for broad impact on public records requests.
Well, I certainly agree that the value of public records should be talked about in various places throughout any report that we end up providing. With regard to, and putting it up above is I'm in complete agreement with, so we ought to add that in. And if, to the extent that you're talking about not only adding it there, but also removing it here, I think it's important that if we're talking in a specific section about the specific issue of broad public requests, that is, public requests that cover some large amount of information, the specific value of broad requests themselves need to be discussed if we're going to discuss the supposed burdens of them. I mean, there are important reasons for broad requests. Just by way of example, when you're getting large statistical information to see how the government handles certain types of situations across the, let's say, thousands of times perhaps that it handles something. It's important to know that, whether we're looking into something like the impact of race on how the impact of race on individuals who come before a government entity and how that's handled, or anything else. There's no way to do that other than with broad requests. And I don't think that's just one quick example off the top of my head. So I do think when we're talking about broad or bulk requests, there are specific values and very important reasons to allow for those requests. And I think that needs to be discussed anytime somebody starts saying, you know, we should be limiting that or charging for that. I think the specific values for those should be looked at.
This is Brittany Walker, if I may. This section is in the evaluation section. This is not in the recommendation section. This section is about evaluating several topics that the legislature tasked us with. And one of those is evaluating the impact of records requests that are broad on government entities. It's not saying we are limiting broad records requests. It's not saying we are doing anything that broad records requests aren't valuable. It's simply asking us to look at, if a local government entity gets a very broad request, how does that impact the government entity? What do they have to do to respond? And what is that? So it's just completely misplaced to have a bullet point to identify the value of the request, because that's not what we're being asked to look at. We're being asked to look at, how does this impact the government entity? And it just seems like some of these bullet points that are added are kind of defensive. Like, there's this sentiment that some of the local government members just want to use a report to, it just seems like there's just a negative implication here when we're just being tasked with a job to do. And these added bullet points are just looking at, quite frankly, attacking, I think, local government entities. There are realities here that all local governments, all government entities in general in the state can find a public records request to be burdensome. Equally valid is those seeking those records sometimes run into roadblocks in getting records that should have been disclosed. But we're looking at both things. And this section is about how it impacts the local government entities. Thank you.
Colleen McCarty for the record. I believe that the title of it was Impact of Broad Public Records Requests. The legislature created this body with 5 transparency advocates and 5 government entity representatives so that we would be providing balance. All this is an attempt to provide balance. If you're going to talk about the impact on broad public records requests, whatever that means, which I think we should talk about how that's even defined, then it only makes sense to have both perspectives included. I'm really not understanding what all the pushback here is.
Colleen, I'm sorry, Kaylee, for the record. AB 128, the law does state that this section is for, it says what it said in the previous section. I hope it was complete. Let me see.
The header is Impact of Broad Public Records Requests is how it's reflected on the template.
Yes, and if you go to the section 1.2 objectives, those titles are full in length. It says the impact of broad public records requests on governmental entities. So those headers below, that is for each of those bullets was merely simplified. I just wanted to call your attention to that.
This is Matt Christian. I mean, I kind of agree with the overall sentiment from Brittany and from others on the government side. The bill specifically wants us to evaluate very specific items, and then there's a different section for making recommendations. So I think all we're really saying is that we need to be sure that if there's a recommendation to make a change in the law, that it's going to be appearing in section 4. If we're just evaluating the current state of affairs, then that would be something appropriate for section 3. That's pretty much what I'm hearing. And to kind of piggyback off on what Ben was saying, the way I read, or the way I think we could read this change that you want to make, adding bullet point that's now would be number 4 about the value. What I saw in that is that we're talking about broad requests and the impact on the government agency. Part of the impact on the agency is that we're not allowed to ask what the value is. We can't ask the requester, hey, why are you asking for this mountain of information? Because if we do, the requester can justifiably say, you know what, we don't have to tell you. So a part of the impact on us is we wonder, why are we spending this many hours on a certain project, but there might not be any public benefit to it at all. So to the extent that maybe we could reword it in the sense that all we're doing is evaluating right here, the evaluation is that government entities must respond to very, very broad requests, regardless of whether there's any public value. That's kind of how I would assess it at this time. That is the evaluation. It doesn't matter whether there's any benefit to it or not. You can still send the request.
Well, I think it's important to the extent that we're discussing it for anyone reading this to understand the negative impact of reducing access to records. And if we're talking about the impact, I mean, if we're really going to parse out the title of this section or what it's talking about, I mean, it's basically talking about a discussion of broad public records requests. But even if we're going to parse it the way you all do, unquestionably one of the impacts on government is the extent to which the public, once they get the bulk request responses, can then analyze what it is the public, the government entity is doing. So I do think the loss of value of obtaining these requests to the public's ability to oversee, and therefore the governmental entity's ability to make changes, is part of the impact. There is real impact on the government entity from not providing these records, and I think that needs to be discussed. And
This
included,
is
I mean, in
Brittany
this section.
Walker. Apologize, I didn't mean to interrupt you, Ben. Brittany Walker, if I may. Everything you said has value. It just doesn't belong in this section. Section 3.3 is about the impact of fraud requests on government entities. And it is not a recommendation that requests be narrowed. It's simply to be a summary of when we get a broad request, this is how it impacts the government. Provide case example, identify resource implications. All of these bullet points that were added, which the other two I think are good things we should look at. Identify value is just so abstract, and like Matt said, which was a great point, we can't ask them what they're asking for. So how do you value it? I don't see that makes sense here in this section. The other two, I like those. I still think they belong in this section because again, this is just about evaluating the impact of the records requests on government entities. And these other bullets, I think, could probably fit somewhere in section 4. Thank you.
Well, again, I respectfully disagree. I do think that there is a way to look at what the value is, and that is looking at past bulk requests and the impacts that the information coming out has had on the operations of government entities. We all know that there have been requests in the past for bulk information, and once it was analyzed and problems were identified, government entities made changes for the better. And that is part of the impact of broad requests, and I think it fits in here precisely.
Leslie Nino Piero. Colleen made a point earlier that we should perhaps try to define what a broad public records request, because, and I think some of this back and forth is a really good, in my mind, is a great example of why that definition is needed, because what you're describing, a request for bulk data, in my mind, is not a broad public records request. You're asking for very specific set of data that the agency likely keeps as a record. In my mind, how I would define a broad public records request is something I can give you examples of where I have received records requests that are 83 pages long. I dealt with one on Friday that was 11 pages long with multiple subparts and then subsections under that. These are more complex than, as a commercial litigator, than many of the discovery requests that I dealt with as a commercial litigator. When I am speaking about broad public records requests, that's what I am thinking of, not a request for data, no matter how big the length of time the data request might be. So it may be helpful for this conversation if we try to put some meat on a definition of a broad public records request.
Kaylee Work for the record, and I agree with that, Leslie. I think when we hear broad public records request, that probably means very much different things depending on what agency we're in as well. So I think identifying maybe the definition gap here might make some sense.
Okay, shall we move on through our template? It looks like our next section is 3.4, cost, burden, and time constraints for redaction. I don't know if anyone wanted to make some comments about some of these or any of the revisions.
Leslie Nino Piero, and this is related to both the previous section and this one. I'm going to put out a request for information, summaries if there's state agencies that would like to provide examples of what they would consider to be broad public records requests. And then if they have any costs and like hours summaries that they may be able to provide to help provide concrete examples for our report.
Thank you. I think that'd be very helpful. I had a question just listening to the discussion. Are broad public records requests, and we've also heard about records requests that are used for commercial purposes or for profit. Are those the same thing, or are those different, and how are those differentiated?
Leslie Nino Piero, from my view, I think certainly commercial requesters can make very broad public records requests, but not all. There's some that I would consider, like data aggregators, and generally they do ask for very broad requests, but also we've seen an influx of late with like third-party companies that manage public records requests on behalf of a requester. And sometimes those are very targeted requests, and I would not necessarily say that those are broad. But there's also a concern with the commercial aspect of it, because you don't know if that is going to be what the purpose is, which, as Matt noted, we don't look at that. That doesn't come into our analysis of whether or not something is disclosable. But we certainly spend a lot of time on it. And if those commercial requesters are profiting in some way from those requests, I think that just broadly speaking, it is a different value to the public than would be an individual's request, or even a member of the media, even their requests. Like the value to the public is certainly different.
Yeah, this is Matt Christian. I think there's a lot of overlap between broad public records requests and the cost and burden. I agree with Leslie. There could be a very broad request that has a significant public purpose, and it may or may not justify being able to charge. It just really depends on the circumstances. I'm not sure if anyone had time to review any of the articles that I submitted for today's meeting, but this confluence between burdensome requests that take a lot of time to process or redact, and the commercial use of that information, I think is really exemplified in a couple of the articles that I submitted. There was one about the commoditization of body-worn camera requests. I just thought it was a really interesting article. It really hit home because we're getting more and more requests for body-worn camera, and there really arguably isn't that much of a public purpose. These videos are not necessarily in the news anymore, but they are very good for entertainment purposes. So what happens is these YouTube companies, they'll ask for a body-worn camera looking for something that would be of entertainment value, they may or may not have to pay for it. I think depending on which jurisdiction that we're in. At Metro, we would charge for the video, but regardless if they pay, they would receive the video and then it would be uploaded on their YouTube channel. And it's hard to say that that's really a public purpose. It's more of an entertainment purpose, especially with some of the content. It could just ordinary stops where someone is drunk or someone's misbehaving. It's maybe fun to watch, but it's embarrassing to that person. And the purpose of it really isn't news. The purpose of it isn't to make sure that the officers are behaving or not abusing anyone's rights. The purpose is to laugh at someone who's embarrassing themselves on camera. So to me, there's an overlay between all of these different issues. The cost, the burden on the agency, whether there should be a public value, and how that plays into whether we can charge.
Kaylee,
This is Matt Morris.
Go ahead.
Oh, go ahead, Caitlin. Sorry.
Matt, always.
So I think.
Yeah, go ahead, please.
So, okay. I think along the kind of the same lines of when we're talking about evaluating these topics versus recommendations later on in the report, it might make sense. And I know some agencies and some state government agencies and offices versus local government kind of runs the gamut. But I think the way that 239 is structured now is that the issue of whether a request is overly broad comes in after the request is submitted, and more as part of the agency's response and the calculus. And it might make sense to, I don't know, depending on how we frame this, either as part of the evaluation of what is a broad request or as part of the recommendation, we should have something uniform for requesters at the front end to say to a requester, before you submit the request, here's what would be helpful in focusing your request to maximize the likelihood that you'll receive a responsive record. Rather than submitting the request and then putting that on the agency within a 5-day period to respond, and then it becomes working with the requester after it's already in the queue, maybe we should either recommend or we should evaluate whether it's feasible to have something uniform that goes out at the front end. Here's an example of an overly broad record. Here's an example of how to focus if you're looking for X, Y, and Z, right, to maximize the likelihood that you'll receive something. And like I said, I think the issue really is I think some agencies may be better about doing that at the front end than others. So I don't know where that fits in, if that's a 3-3 or a 4-3, I don't know, but I think helping the requester before it's already, before you've submitted something, I think is something that makes sense.
I'll go ahead and add to that too. Providing a contact person for requesters or a mechanism by which they can actually contact the agency to be able to have the discussion. Hey, I'm looking for this, and I don't know if I'm asking for the right thing or not. But so often now what we're seeing is it's just a portal and it goes someplace and there's no contact person that you can reach out to once you submit it through the portal to be able to have that conversation. So if there's some mechanism, point person, I don't know exactly what it looks like, but I think that would potentially help a great deal in getting everybody together to figure out how can we craft this. But there needs to be accessibility to someone for that to occur.
This is Kaylee Work for the record.
This is Britt.
And I agree both with Matt.
Go ahead, Kaylee.
Colleen, I believe those are two great solutions that we should keep in mind for the recommendation section too. I think going back, I know we started getting into 3.4, but going back to 3.3 based on our discussion, I do think it's valid for us, even perhaps in an overview section. So I'd like to propose adding another bullet point where we can kind of define what currently may be included in that bucket of broad public records, which probably includes those commercial requests, overly broad requests, vexatious requests, those sorts of things. So I think a lot can fall into that bucket, and perhaps we just identify that. I don't think we need to go into too much detail into that section, but I think there'll be a bigger opportunity to solve for those in the recommendation section.
This is Brittany Walker. I just wanted to say I thought those were great suggestions, Matt and Colleen. One of the challenges we have is, it's at least my interpretation under public records law, that they can be requested by phone, by comment form, and that we can't tell a records requester they have to fill out a specific form. And that's been a challenge for us as a local government entity who, when you request a record from Boulder City, you do talk to someone immediately. And we do frequently reach out to the requester when we're not sure what they're looking for and say, hey, can you give us some more information? And I understand that's not how everyone does things. But I just agree with all those suggestions. But part of the challenge is not being able to require the requester to follow a specific format or use a specific form if they don't want to.
Yeah, this is Matt Christian. I agree. Those are really good ideas. I know at Metro, what we do is we do have a portal. We try to encourage people to use the portal so that we can keep track of the requests better. The portal has a form on it, and it asks for specific information like an event number or names or dates or locations, so that we try to help them narrow the request. But then, like Brittany says, we really have to accept a request no matter what it is. So the final part of the form is just a free form section where you can type in anything you want. So if you don't have an event number, or you don't have a date, or you don't have a name, or if those things don't really even apply to your request, you still then have a chance to submit the request. And we, unlike Boulder City, I think we get too many requests, so we don't have someone that picks up the phone necessarily when you call the public records unit. But I know there is contact if we don't know what the request is, or we need for it to be narrowed. We do our best. I'm sure there's criticisms of it, but we do our best to try to get the requester to narrow the request into something that is more manageable, or something that is where we can actually identify what the record is. But those are really good points. If we had a more standardized way of doing it, I think I would be in favor of that for sure.
Okay, great suggestions. Something I guess we can keep working on as we go through this. And I don't mean to limit us just to going through this one by one through the template, but I'm just, in the sake of keeping this going, I'll keep doing that, but please feel free to move around on anything anyone wants to. Did anyone have any comments on the redaction section? This is again in the findings section of section 3, cost burden and time constraints for redaction.
The only thing that comes to mind this is Kaylee for the record, is the technology piece and the cost of technology. I just imagine this will look extremely different for every agency throughout the state. So I don't know, I wouldn't know how to, I think in this section we can clearly give examples of some agencies. I think it would just be hard to quantify at an all-up level.
Colleen McCarty for the record. We put that in because there are sort of wide variety of different technologies that various entities are using. And we thought it might be helpful to try to itemize some of the things that are out there and that are working, so that if we wanted to make a recommendation to create funding for those types of software or different types of tools, that would be a mechanism by which to start looking at that.
Does anyone
This
want
is
to?
Leslie Nino Puro.
Yeah, go ahead.
I'll just add to that, Colleen. I think it is a good idea for us to talk about technology because some of it is quite expensive, and as is, I know my agency and many state agencies are limited by staffing, but then technology also becomes that would, in some ways, allow us to work with less staffing. Then the technology is not available because the funds are not there for the technology. So I do think that is a really important inclusion. And of course, the lack of staffing and lack of funding then increased delay. So these are all very related subjects and appropriate for us to talk about in the report.
Is there, I mean, is there kind of a list or different types of technologies used for redactions? I'm just not, I'm not aware, or I don't know, I'm sure there are. I mean, other than someone going through it with a black highlighter, how does it work?
It depends on what it is. For example, I know some police departments, when they're dealing with their body-worn camera redactions, they have special software that goes along with the body-worn cameras that can do the redactions automatically. So a person doesn't have to sit there and go through frame by frame like they used to. I know there are different entities that are using AI to try to sort through requests and more closely identify what people are asking for, what may exist within their own systems. I think it would be helpful to reach out to lots of different agencies and see what people are doing and what it's costing them. You know, maybe one of our requests is a budget for some entities and agencies to apply for to try to get some funds for some of these things.
This is Matt Christian. So we are looking into AI at the moment, but for the record, right now, body-worn camera is reviewed frame by frame and redacted with the evidence.com software frame by frame. We think that we can expedite that and make it easier in the future, but the software was not sufficient. The last time that we checked, at least a year or two ago, it would, if, for instance, we were required to redact officer faces, there was a function to redact a frame with the face and then have it follow the face around. But what we found is that it didn't actually do that all the time. So it still had to be reviewed. It's still kind of a painstaking process, but we do expect that in the future, it would be easier. In terms of documents, you know, we have the documents, if they're in Adobe, then instead of a black marker, we have staff that uses Adobe to apply black boxes to the redacted information. That still takes some time. There's still a human being involved in doing that. Again, maybe hopefully in the future, maybe even the near future, AI will assist in that process. I think you're always going to have a human involved. Just like for us lawyers, we can't submit briefs that are written by AI without checking them first. So I think the same is going to apply with redactions. If we have a lawful legal obligation to redact something, we're not going to be able to just rely on AI completely to accomplish that. But I think we'd be very willing to share our costs of technology for our portal, for our staff. I'm not sure if Leslie's going to include that in her survey, but I think it's good to evaluate that if we're in the evaluation section. The actual cost to entities, I think, is something good to include in our report.
I know, for example, Reno PD is using AI to do its body worn camera redactions. So the idea is to see what's out there and what's working and what it costs as a way to try to solve some of these issues.
I had a question on the additions, the additional bullet points. Identify problems with delays. We're in section 3.4 here. Are we we're gonna be providing examples of costs and impacts. Are we gonna have examples from the transparency side of problems with delays? I would just suggest maybe you can do a survey too. It'd be good for us to see, you know, if we provide records in 30 days instead of within 5 days on a broad request, for instance, what is the problem that occurs from that with a specific example?
Yeah, we can provide lots of those if need be.
This is Brittany Walker. I would just echo that my police department also does frame by frame redactions, and we currently, just for other types of redactions, our staff manually reviews the documents for personal identifying information and redacts.
And again, it's Matt Christian. The redaction is one thing too, but it's the finding the records too. That's a laborious process. So if there's a request for any and all records on a certain subject, at Metro, we might have 10 different databases that have to be consulted with. Just for any criminal file, there would be 911 is in one database, body worn cameras in a different database, arrest reports are in a different database, emails are in a different database. So the humans still, maybe AI will take this over someday too, but at this point, the humans still have to know how to use each one of these systems. We have to give them access to each one of those systems, and they have to, you know, undertake some kind of effort to query each one of the systems to pull in the information before it can be redacted. So it's part of the cost burden too.
Kaylee Work for the record. Moving to section 3.5 on the financial burden. Obviously, there's a lot of different fee structures from agency to agency. I know it varies even from, I imagine, county to county, city to city. I think this is a good place for the transparency side to maybe provide feedback on the inconsistencies across agencies.
I would also be interested to know if, at least for our government members here, if they could provide their fee structures and we could include them in the report. I think that's another way to look at how things sort of differ depending on where you are. And also, it would be helpful to know, and I don't know what the best way to achieve that is what each agency's definition of what they can charge is. We know the statute provides that you can charge the actual cost. So I'd be curious if different agencies had different definitions or policies that sort of define what they feel the actual cost is.
I'm Leslie Nino Puro. I can't speak for everyone, but I would imagine that that's reflected within their fee structure. So if they're charging for, let's say, for postage or for CD, then they would see those as an actual cost. If they're charging for research time or redaction time, then perhaps those, what I'm worried about is that if we ask, if they have it written in a policy, great, but if we're asking them for a statement of it, that perhaps it's, we're asking them to provide a legal analysis of how their agency defines it, and that might be problematic. That might venture into something that we wouldn't get the same voluntary participation as if we're just asking for a fee structure. And what are your published policies for charging fees?
Yeah, I mean, if the fee structure includes cost of review, cost of redaction, fantastic. Often they don't. And so that's what we're looking for, is have different agency established. We are charging X amount of money per hour for redaction, or X amount of money per hour for attorney review, or how that has been quantified agency to agency.
This is Matt Christian. I would just note that oh, sorry, Brittany. I was just noting that the NPRA requires agencies to publish their fee schedule. I know the Metro does that every year, and we can only publish the fee schedule after an open meeting. So every year our Fiscal Affairs Committee approves the new fee schedule, and there's been public records requests for the backup for the fee schedule, and we've provided that in the past to explain where the fees are coming from and what the legal basis is. So with that said, I don't have a problem providing our fee schedule. It's on our website, and it's part of a public record every year in terms of when it's approved. My other comment here is on 3.5, the last bullet point that's been added. I don't have a problem if our transparency friends want to identify instances of government entities imposing charges in violation of the law. If that's what their opinion is, I would just ask that if a particular agency is going to be sort of accused of violating the law, that they just be given the opportunity to respond. So I know I've had arguments in the past about whether Metro can charge, and if I would just ask that if Metro is going to be one of these examples, that I would just have the opportunity to explain my legal rationale, which I've provided to probably people in this room, what my legal analysis is. So I actually don't have a problem providing my legal analysis if that's what we want to add to the report.
Can I ask for the folks on this committee, do your fee schedules include research fees, redaction fees?
Yes.
Because I'm looking at yours and it just says varies.
I think if you look, there's staff time depending on where you're looking. Research fees, if it's a burdensome request, and there's asterisks explaining the legal basis, or at least citing to a couple of statutes that provide the legal basis. There's some of our bureaus are charging on a per document basis. For instance, if you file a police report, you're a victim of a crime, and a month later you need a copy of the report. If you go to an area command, or if you go to Metro headquarters, you can get a copy of your report, but there's a fee associated with it, and that's on our fee schedule. If you're going to submit a public records request or a body-worn camera request, the labor charges are accounted for on our fee schedule. The RJ writes an article about it once a year when it comes to our body-worn camera.
Right now, it says body-worn camera video cost is $89 an hour. Sorry. I'm looking at the Metro website right now. It says body-worn camera video, $89 an hour. Research fee for records and information not readily available per hour cost varies. redaction fee per hour cost varies. Is there a figure that you all have come up with for those things?
Yeah, it's the body worn camera and any research fees. It's the actual cost to Metro of the employees who will conduct that task. So for instance, if the employee makes $50 an hour, then the charge would be $50 an hour. The detectives who are conducting the body worn camera gathering and redaction, the cost to Metro is $89 an hour. So that's what we charge. It's the actual cost.
And how does Metro, for example, decide which employee to use for those things? How do you decide if it's a $50 employee or an $89 employee or $25 employee?
Well, we try to make it the most cost effective that it can be. So for instance, body worn camera, we've decided that commissioned law enforcement personnel should be the ones doing it, because a vast majority of requests for body worn camera are coming from insurance companies and personal injury lawyers and personal injury defense lawyers who want all the video of the car crashes. So to kind of force a civilian, more of a frontline employee who's paid at a lower rate to conduct that kind of review of gruesome video that often will have to be, redacted with, blood and missing body parts. We've decided a long time ago, actually, that a commissioned detective should do that. But then when it comes to gathering emails or gathering other kinds of documents, then we have civilian employees doing that. So the charge is much less.
Thank you. That's really informative. I'm happy to reach out to different agencies to collect as many fee schedules as I can find. And if there are any entities in particular that anybody would like me to reach out to, please just let me know, and I'll try to compile some additional information for this.
And this is Brittany Walker. I was just going to point out that the Nevada Independent recently did an article on this, at least for Southern Nevada, and they have a little list published as a starting point.
Great, thank you.
And this is Stacy with Lyon County. We have a fixed fee schedule also that for each department, it does vary, and I could send that to you or to the group if that helps.
Yes, if you would send it to me, that would be great. Thank you.
Leslie Nino Puro. I'm going to be requesting the same from the state agencies that I have their counsel within my office. So probably better use time of going outside for local government or municipalities rather than state agencies. I'll try to cover that for us.
Perfect.
This is Stacy for the record. I had one more comment. For us, if it's easy, I mean, we try to turn our responses around quickly. And I'm in the clerk treasurer's office, so I don't have the body cams and things like the sheriff's office do. So it seems so, I mean, to apply the same rules to the clerk treasurer as we do to the sheriffs and courts seems kind of really broad to me because of the needs of the public and the information the public needs. Most of our requests are pretty simple and they're post and send, So I think, I mean, I don't know if we would want to look at even a separation of those because, I mean, I think that's where the problem lies. Just my thoughts. Thank you.
Okay, well, Colleen, thank you for taking on the assembly of the fee schedules. I think that'll be great information for us. Should we move on to the next item? This is 3.6, dispute resolution mechanisms. And this is another one where a few additional concepts were added to this one.
Colleen McCarty for the record. I'll also add that I'm in touch with the Reporters Committee for Freedom of the Press that I think is going to present for us at our September meeting. And I've asked them to look around the country to see if there are models of dispute resolution, ombudspersons, something along those lines that are working in other states. And hope to have some more on that in the future.
This is Brittany. I just have a question. I think it's for Ben again. What does identify ways in identify ways in which such system could be used to undermine the Public Records Act? I mean, what is that? What would that look like?
I think it would look like ensuring that having an ADR system didn't delay things more than they otherwise, delay the provision of records more than they otherwise are, delay the resolution of conflicts, that it didn't end up costing more money for requesters, either because of the money they had to expend in the time and money in the ADR process itself, or ensuring that it wasn't set up in a way that it provided a mechanism for government entities to pull reluctant requesters into court. Issues like that, that in the end, it became, in a sense, a tool that made it more problematic for requesters.
Okay, that makes sense. Would you be amenable to wording that just more positively, like saying, ensuring that the process isn't delayed or isn't used, that identify processes that maybe uphold requesters' rights, or just something that's more gets to the kind of the root of what we're trying to accomplish?
Sure. I'll look at other language.
This is Kaylee Work. I just wanted to note that someone added provide use of mediation. I didn't have that on the original template. I don't know. There's no track changes for that one. I certainly think, so whose ever comment this was, I certainly think a use of mediation makes sense for our recommendations page. I just don't know that it exists right now to belong under section 3.6, unless that comment was really used for maybe mediation practices that are happening in some agencies and not others, and it's being used as maybe a best practice. I just don't have more background on that comment or know who submitted that.
This is Matt Christian. I don't know if this is a good time to talk about and just put on the record what the current processes are, and maybe to have a discussion about what a different process might look like. And then I guess my other comment would be, this sort of reminds me that this report was going to have to be filled out a lot. So I don't know if we're going to be dividing up the sections. The bullet points are, I think, a good start, but identifying the existing process probably someone's gonna have to type up a more fulsome paragraph on that. I'm happy to do that, or at least some of the sections. But I think we know what the current process is if a requester is not satisfied either with the response or the holding of records or redaction of records, or with the length of time that it's taken, then the requester has the ability to file a lawsuit in court against the public agency. And I think there's a lot of talk about how that process can be burdensome and time consuming. In my experience, it has been most of the time, depending on the circumstances and the complexity of the request. But really, in theory, it shouldn't be that hard. It really should, if it's just a legal question of, is this type of record a public record, or is it confidential or not? It really should be a petition for writ of mandamus that's now recognized as the method of the lawsuit. Then the government agency replies or responds, and then maybe the requester does a reply. Then you go to court, and then you get a ruling, and it really should be as simple as that. The Public Records Act, at least it contemplates that it's supposed to be an expedited process. So either one of the parties could ask, at least a court here in Southern Nevada, for an order shortening time. So it wouldn't even necessarily have to take the ordinary 30 to 40 days to have a motion heard. It could really be faster than that. The last time that Metro was sued under the Public Records Act, that's really exactly what happened. I had a lawyer who really wanted juvenile justice information, and he filed a petition. I filed my opposition. He filed a reply. We went to court, and it was resolved, and that was it. It was over in 40 days. So I'm not against mediation. I'm not really against an ombudsman necessarily. I'm just suggesting that the process doesn't necessarily have to be overly complicated or burdensome. My other comment on that would be, I really don't even think that a lawyer is needed. If you were a requester and you don't get what you want, again, I know at least here in the 8th Judicial District Court, there's a legal aid center in the courthouse. They have plenty of other forms that folks that don't have lawyers can fill out. At Metro, say, we have your possession of your property, we seized it for whatever reason, and you want it back, and you can't get anyone at Metro to give it back to you. You can go to the Legal Aid Center. They have a one-page form that's a motion for return of property. They fill it out, it's filed, and then suddenly Metro has to respond to it. So I don't necessarily think the litigation process itself is necessarily a bad process, but I would be interested to hear what everyone else thinks about that.
Colleen McCarty for the record. I think what we're seeing, at least in some of the written public comment and some of the public comment requesters that we've seen, it's just cost prohibitive. Even a filing fee at the 8th Judicial District Court is $400 and some just to file your case. So I think when you're dealing with larger companies and government entities that have resources for these kinds of things, that's one thing. But for the average person who's just trying to get some records, it's very cost prohibitive. So I don't know if there's a model that works. I'm looking to try to find one to see if there's a model that works. But I think that's really the issue for the average person that's trying to obtain public records.
This is Matt Morris. I think to Matt Christian, to your point in your discussion, I agree. And I think there was a presentation during the last meeting from one of the media presenters that referred to some of the land use, like judicial review, self-contained procedures in in the land use statute. And I think that statute is basically what you just described, expedited briefing, a very quick process. And so I think there is some agreement among the presenters that something like that is needed when there's a dispute that does need to be resolved in court. But I would also, just say that whether it's mediation or whether it's more of an education issue on the front end, kind of like what we were discussing earlier, is I do think there's consensus that shouldn't be the first thing that happens. It shouldn't be, 5 days into a request and then you've got a mandamus petition and folks are on their way to court, right? And I do think that the way that the statute is sort of structured now, there's a bit of an intervening moment where the agency can help a requester potentially. But other than that, it's extraordinary relief. You're going right to a mandamus petition, right? So if there's a way to find some sort of a buffer system where you're not adjudicating, right? Whether it's because there's a legitimate confidentiality issue or whether it's because there's a vexatious, overly broad request, either way, if there's a mechanism to filter that out so that it's not going right to court, I think there's some consensus on that issue.
This is Matt Christian again. That's a great point because in the example I had just given, we were surprised when the petition for writ of mandamus had been filed because unlike most of our requesters, there was no interaction. The request clearly was for juvenile justice information, which is probably one of the clearest areas of Nevada law, making something confidential. And the attorney had a legitimate need for it because it involved his litigation. But rather than reaching out to our public records unit or trying to get a hold of a lawyer in our office, he went straight to the petition for writ of mandamus. And when we received it, I actually reached out and said, hey, look, here's the law. Are you really sure you want to carry on with this? I can engage in a discussion with you. And he didn't want to do that. It would have been nice had there been a requirement that there be some back and forth before there's an ability to file that lawsuit. But again, I would just reiterate, I would be open to a waiver of fees if you can show that you're indigent. There is no filing fee. I'm not sure exactly what that process is, but I don't think it's very hard because just in my experience at Metro, right, we can be sued and there's no lawyers involved at all. It's just a pro se person. They get fee waivers and we end up having to respond to the lawsuit. I know it can be done. And I think a motion for return of property is just a good example. If there's a form for it, I don't think they're charged to file that motion. But $400, if you're just an average person who didn't get public records, I don't disagree that is excessive. I don't think that should necessarily be required. That fee is more for regular commercial litigation as far as I would be concerned. Does anyone think that mediation should be required? Does anyone think that a statewide ombudsman would be a good idea? These things have been discussed in the past.
This is Ben Lippman. Sorry, go ahead.
Hey, you can go ahead, Ben. Sorry, I can't see everyone. You're very tiny to me, so I'm not sure when people are talking.
Thank you. I don't think there should be a requirement to the extent that you were asking for that. I think it should be an option for requesters how they want to approach it. I think most requesters probably would welcome the option of something short of litigation, and I think it would provide a great benefit, but I don't know that it should be a requirement that they go through it. Again, my concern getting back to what Brittany and I were talking about earlier, would be the extent to which it simply added layers that would cause further delay and further cost, whether in time, money, or both.
This is Brittany Walker, just thinking out loud. I would be in favor of a sort of a mediation step or even an administrative review step, like with most things, like what Matt Morris was pointing out with the land use process, or for example, most jurisdictions, if a business license is revoked, there's an appeal process internally. Usually hearing officers are used in a lot of jurisdictions, and the hearing officers are usually not employees of the government entity. There's usually qualifications in there. So I don't know if there could be some sort of hybrid type of layer, that's because I think an ombudsman, while it would be great, I think it would be very costly for the state. And I think there's probably ways to provide a similar pre-litigation step. Whether it's mandatory or not, I would defer to the legislature on that. But I think just having it in the statute as an option would be helpful. So, and again, those are my thoughts with the hearing officers. You could make it so that the person's not a government employee, that they have to have certain requirements, that they're have experience in public records or things like that, so that there's an impartial third party looking at it first. And I think that could be done pretty low cost.
Haley, work
This
for
is
the
Stacy
record.
Leberg for the record. I actually worked with mediation when I was a foreclosure agent, and a lot of times it was almost just as expensive to pay mediators and people to mediate for us as it was to just take it through a judicial foreclosure. So I'm just curious, because I know there's paid mediators out there. I mean, if we did offer mediation, like you said, would they be qualified? What would their backgrounds be? And what are they going to charge?
This is Kaylee, work for the record, and I just want to thank Colleen. I think you mentioned that you're doing some research in this area for best practices, so I think we'll learn a lot more and have a better, stronger dialogue once we kind of can narrow down what some of those pathways are. I obviously do think, based on what I'm hearing from certain presentations and public comment, is there certainly a need to have pre-litigation mediation piece, whatever that looks like. I would be interested in seeing that also tied to delayed responses as well, as records are either not obtained or not provided, perhaps at some point in time that intermediary steps in.
Leslie Nino Piero for the record. I believe we mentioned earlier a person or some type of resource on government agency websites that would provide like best practices. So perhaps one of the, we're talking here about evaluating ADR step, alternative dispute resolution step after an agency has made a decision, but it might also be helpful to have this third party person also be a resource with those types of best practices for narrowing a request and receiving records from the government that may be available to help a requester better craft their records request. So my point is that in addition to the after effect of a negative decision, perhaps having a resource available prior to submitting a request that could help a requester craft a request so that there's not, many times there's frustration on both sides, right? They're both on the requester because we're speaking two different languages. And rightfully, as some presenters have pointed out, requesters don't know what type of records we hold. And I typically don't know what the requester is looking for. And they're not really explaining it very well. Like we're talking past each other. So that might be on the front end, might be an option for a recommendation that could be very fruitful.
All right, any other comments on 3.6? Any comments on 3.7? It doesn't look like there are any suggested revisions here. This is data collection and sharing methods. Okay, seeing none, we can leave that, flesh these out as we keep going, but we can move into the meat of this, the recommendations themselves, section 4. Section 4.1 is clarification of custodianship and control. I know there's been some concerns here about what agencies, when they have custodianship of documents and when they don't. I don't know if someone wanted to kick off the discussion on that or had some ideas on how we might start thinking about that issue. Or are there any concerns with custodianship?
This is Brittany Walker. I would just say something that comes up frequently is when another government entity really owns the record, but we have a copy of it for whatever reason, and then it's requested from us, and whether we are the person that has to get, I mean, I think if it's in our possession, we give it, but then if there's other confidential information or things we're not aware of because it's not our record, or even, court records have different rules that apply to court records, and like if my office has court records, that type of thing.
I think this is Ben Lipman. I think we find that too often government entities don't treat it, Brittany, the way you do, which is that if you have possession of the record, you have possession of it, and if it's a public record and not confidential, you turn it over. To me, the law is clear that that's what the law is, but we run into problems enough that perhaps it needs clarification that, if a government entity has a record, then they have to turn it over unless, there's a confidentiality that applies to it.
This is Matt Morris. I just, to dovetail on that a bit, more with just an observation of how I think the law is unclear, is that, so 239.01.07 sub 1 deals with the entity that has custody or control. The impetus is on an agency assuming that it has custody or control of the record. And so an entity that has custody or control of the record is required to do several things. One of those things is to respond, I don't have custody or control of the record. So that's an example of the language in 239, I think, is just inconsistent on its face. And those are, I think, the types of things that we should make recommendations to the legislature to clarify, right? I think there's a lot of instances of that in 239, but if you go through that exercise and say, well, so what does that mean? If I'm the entity that has custody control and I'm responding that I don't have custody and control, right? So just to kind of maybe highlight that a bit probably for further discussion.
This is Matt Christian. Yeah, just to dovetail off what Matt said, the statute actually says legal custody and control. It's not just custody control, it's legal custody and control. So maybe unlike Boulder City, Metro usually takes the position that if we just happen to be in possession of the record, but it's really someone else's record, we will at least often defer the requester to the proper agency. So just to give you an example, we could very well be in possession of a coroner document, but we would tend to defer the requester to the coroner directly. There's another statute that requires us to provide the address of the entity that's in legal custody and control of the record. I think part of the reason that we do that is that it could be that the coroner is more familiar with whether their records should be disseminated, not so much Metro. And we would sort of hope the same would be extended to us in return. If the coroner was in possession of a Metro document, I would hope that they would, defer the requester to Metro so that it could be responded to directly. My other comment on this is that the statute, like Matt pointed out, it says legal custody or control. It actually never says possession, custody, or control. And that's really very different than Rule 45 governing subpoenas. If Metro receives a subpoena in a civil lawsuit for a record, then if we're in possession of it, then we will have to provide it because Rule 45 specifically says that. So to me, I guess what I'm saying though is that I agree with Matt. It's open for debate. We're often having this debate. Does Metro have to provide this record when we're not in legal custody or control of it? And I guess my final point on this would be going back to our last meeting. I think we talked about evidence. And I think I even asked a couple of our presenters what they thought about evidence. So, and maybe it's maybe not so much about custody and control as it is about the definition of a public record, which doesn't exist. But it is sort of about legal custody and control because I think the example I gave last time is when the police are in possession of somebody else's property, like the contents of their phone or their home surveillance video that they gave to us with their consent for the purpose of figuring out who robbed their home. Those, I think it's a good argument anyway. I know that all of us in the room don't agree, but is Metro really in legal custody and control of your surveillance video that you gave to us? I would say arguably it's not, but I know that, again, not everyone agrees. But if the law is clear that mere possession of your cell phone contents is a public record that we have to provide, then we would do it. But it's not clear at all right now. So it would be nice to get some clarity on this topic of what does it mean for us to be in custody and control, legal custody and control.
This is Leslie Nino Piero, and I'll just echo a little bit of what Matt said. The Attorney General's office, of course, we are the legal counsel for state agencies statewide. And so, of course, there are many documents that we will have possession of based on the attorney-client relationship. And of course, that has its own rules and restrictions. But I think it's another example of where we may be in possession of a document, but it's something that I would defer to the agency as well, and saying that that is not within our legal custody and control, and that a requester would need to go directly to the agency that created the record, because they are ultimately the master of their own chapter. And many times, although I may know Chapter 239 pretty dang well, or even 228, because that is the Attorney General's Office chapter, I cannot possibly know every other chapter in Nevada law, and it is most appropriate for the agency who created the record to be making those calls on confidentiality and disclosure.
This has been, I certainly agree with you all that there's a difference of opinion on it that could bear some further clarity in the law. And I do think it's something we should work on. I'm not sure if we're going to come to an agreement on how the law should be, but I think we all agree that it would be nice if the law were clear on what it is.
Any other comments? It sounds like this might be an area where we are making some recommendations for that custodian clarification is custodianship and control may or maybe not includes mere possession. Are there other issues within that definition that we should be thinking about as well? Anyone wants to bring up? Okay, if not, maybe we go to our next topic, protection of sensitive information and transparency. So I don't know if anyone wanted to start off with identifying any concerns about how to best strike the balance between privacy and public access.
This is Brittany Walker. I'll take the first step. I just, one of the frequent requests we'll get, we, as a government entity, we have possession of a lot of information of private citizens. We have utility customers. We know their water usage and their electricity usage. We have their building permit files with plans of their homes. Private citizens who, aren't involved in government other than being a resident. And sometimes we get requests for those records. Some of it's aggregate data. Some of the, definitely could be a public interest in asking for some of the information like water use because we're in a drought. But some of it, we've had people ask for private homes, utility usage, just resident to resident requests. There's no real reason why they need to know that, but they want to know, they're trying to dig up information about somebody's who rents 5 homes and whether or not those homes are being rented and who's in them and just strange things like that. And so because we can't ask the purpose of a request and, because of there are concerns with people requesting, information of private residents without really a public interest in knowing that. And we have all that information and there just should be some clarity. We usually use the balancing test. So, but just in general, that's an example of sensitive information that the government has that could be used to, you know, especially if there was like a domestic dispute and someone's trying to find out where their ex-girlfriend moved to or things like that. Or boyfriend, not to be gender specific.
This is Ben Lippman. I think that you know there are two different issues. One is whether there are statutes that cover specific information that people think should be kept private, and of course, with 597 or whatever it is statutes out there making information confidential, we certainly have a legislature that's not shy about looking into and ensuring that information that government gets that is about private matters and that it has for one reason or another that shouldn't be made public is kept secret. On top of that, of course, there's the balancing test. Again, coming from the side that's typically asking for information, more often than not, we find that the CCSD privacy balancing test is overused when you're talking about information that the legislature has not seen fit to declare as private, but nevertheless is kept private, and that the test itself, the way it's often used, I don't think the court's intended this way, but again, there may be a difference of agreement in this room. That's just my opinion, but regardless of whether it was intended that way or not, that governmental entities tend to, in our opinion, and in many on the transparency side, overuse it and use the test in a way that they withhold information simply anytime somebody's name is mentioned. And one thing I do think I'd like for us to discuss in here is, although again, I don't think the case law treats it that way, but to the extent that it's used that way, perhaps a legislative cure to make it clear just that the bar for privacy isn't just lying on the ground, that there is some real true private interest other than simply somebody's name happens to be mentioned, and make it clear that so long as there's a public interest, you then go to a balancing test where the burden, as the courts have said, is and as the statute says, is on the government entity. So I do think this is worth discussing. And Brittany, to your point, if there are gaps in the statute, I think it's worth discussing whether perhaps there's particular information that somehow should be kept secret that isn't yet. But I also think discussion of the extent to which the balancing test itself is used and a clarification of that.
This is Matt Christian. I think all of us would agree that these balancing tests are difficult to apply. It'd be much nicer to have something clear in a statute that told us exactly what to do in a given situation. So I'm all in favor. I think everybody would be in favor of developing some kind of list of common categories of records that agencies are asked to produce, and a yes or no, is this confidential or is it not confidential? I think there's really so much irony in the statutes. It's almost hard to describe. So for instance, we know without a doubt that if you apply for a concealed carry permit, your application, the permit, if we revoke it, if, you submit papers, everything at all to do with a concealed carry permit is 100% confidential. The statute could not be more clear. It wasn't clear before, then there was a lawsuit, then it became clear. The legislature made it very clear. So I know what to do when someone asks for a concealed carry permit file. It's clearly a no. We've been told it's a no. I have no personal view on that. It doesn't matter to me. The legislature told me that it's confidential. Maybe it shouldn't be, but they told us that it is. But at the same time, Metro could be in possession of a report that, or a witness statement. Let's say it's a witness statement. You come forward, your spouse beat you, we interview you, you have every detail about your life with this person, your sexual history, your work history, your financial troubles, intimate details about exactly how this abuse occurred, where your injuries are. And yet there's no statute in Nevada that tells me, am I supposed to redact your name? What is it private? Is it not private? I would like to know what to do with that record so that I don't have to try to apply this balancing test and wait for there to be a dispute about it. It would be, if the legislature wants to make a report like that a public record and there's nothing about it that's confidential, I think that would be a really bad idea, but at least we would know. So that's kind of where I'm at with it. I would like a list developed, and I have one in my own mind, of categories of records. Yes or no? Do I produce it or do I not produce it?
This has been, so I'm hearing you'd like to get rid of the balancing test altogether.
No, I think the balancing test is a fail-safe. It ends up that it's necessary because the legislature will never be able to account for every type of record that might be in the possession of a public agency. So there's always going to be this need to have a balancing test. The balancing test is hard to apply, but at the same time, it can be applied. The court has given us some direction on that. We know that if the record is embarrassing, if it's going to cause shame, if it's going to cause you danger, then it has to be at least redacted to protect your name. We know that medical information is something that the court has listed. Sexual information might have to be protected. We know that it's tied into federal case law from FOIA about privacy interests. So we have that to work with. We also know that it's tied into the common law tort of invasion of privacy. So you have all that case law that you can look to determine, would society view this type of information as private, or would society not view it as private? So there is a lot to work with. And I think it's necessary to have the balancing test as a fail-safe, but it would be better to try to categorize common things so that we don't have disputes over how this balancing test is applied.
And this has been, to your point of using it as a fail-safe, if we were to keep it around for use as a fail-safe, getting back to what I was saying before, we have found that too often, and that this is the clarity I would like to have to make it be the fail-safe you're looking for, that too often rather than a fail-safe, it becomes the exception that swallows the rule, and having clarity that keeps it as a fail-safe rather than, again, if we don't get rid of it to give you the ultimate clarity, having it be a fail-safe, not, again, an exception that swallows the rule, I think would be very helpful.
Colleen McCarty for the record. I think part of the reason that the balancing tests exist is that lists of things, depending on the context, don't work, right? The example you gave of the abuser, well, if this is a serial abuser who has injured many, many people, and maybe he's a public official, or maybe he has some other important job. Suddenly, a list of you can't ever have a record about a domestic violence incident changes tone dramatically, because perhaps this person has flown under the radar for some time now because the records were secret. So I think that's part of the challenge and why the balancing tests have been created. So I'm not in favor of trying to craft lengthy lists of things, because I think depending on the context, they may or may not work when we look at the public interest in the information. I do agree that the balancing tests are often misinterpreted and not correctly applied. So I think to the extent we could get guidance in that regard, I think would be helpful. Those are just my thoughts.
So just, this is Leslie Nina Piro. I want to just give an observation based on my personal experience working on public records requests, that it feels sometimes as though from an outsider looking in, very little is private, but when we're many times making decisions in the abstract for people we have probably never met, victims or witnesses who come forward. And so we're many times trying to make those decisions in a balancing test as to, like, it feels like many times the requester is not thinking about, well, if it were you, would you be embarrassed by this? Would it be chilling to you to come forward and provide a witness statement? So that's just something that we, I know on the government side, are thinking about every day. Is this going to cause a person to never want to seek help again because their business was put out in public? So just food for thought, and how it is many times applied, and what our conversations are on the government side, and whether or not, there could be repercussions far beyond just this one particular, what the requester is seeking. How could it affect the person whose privacy we're trying to protect? And I'll add there also the potential liability on the government agency for releasing something that a person would then come back and say, you released my private, personal, sensitive information.
Kaylee Work for the record. Just to expand on that a little bit, we're seeing a lot more AI usage. So data aggregators, traditional data aggregators, it's kind of evolving. I'm seeing new companies being built who are creating software with AI, and they're asking for a lot of information, and we don't know how they're using such information. And again, we've talked about that earlier, how we can't really ask, right? Because there's no differentiation in the law right now about commercial requesters and their usage and how they're profiting off of Nevadans' information. I think that's something, I don't know if it belongs in 4.2, but I think it might. That protection of sensitive information, especially when AI, of course, that's just a technology and a tool for how some of these companies are collecting information. But I also want to caution the speed at which they can use that information is much different, I think, than it used to be. In the world of recording, we often think about property fraud and what information scammers use to defraud people. And we're just really entering this world of AI, and we don't really know how information is being used. So when we think about sensitive information as it relates to people's finances and properties, that's something I really like to include in the scope of 4.2. or somewhere here in the recommendations.
This is Brittany Walker. I just want to say I agree with Kaylee. We also, I'm not sure if it's AI, but we do get a lot of commercial requests for aggregate data of our utility customers and things like that. Not sure how it's being used or used to, whether it's marketing or whether it's more insidious than that. That is an issue. And I will also just echo what Leslie and Matt were saying with the issues that we have. I agree that the balancing test to retain it is important. I also think having more clarity in statute of what is confidential with regard to private information of private persons would be helpful to have. I agree that lists can be too restrictive, but I think there should be some additional information because they're just competing obligations that the legislature is imposing upon us. For example, a recent law that was passed protecting information of donors to nonprofits, that if the government entity has information that on a nonprofit where there was a donor to that nonprofit, that the government entity has to keep confidential that that person was a donor. And so we now have to ensure that we keep that information confidential. If we release that information, we could be subject to having to pay attorney fees for violations, things like that. And it is strange to have something like that confidential, but not have other very clear private information, such as a person's home plans and their building permit file, or even just, their electric usage, or even their name and address in some circumstances. I mean, it's in Nevada, you can look up anybody's, how many properties they own and things like that. I don't know that should or shouldn't be confidential, but I have found, I've tried to research, my cousin was interested in buying a property, and I tried to look up who owned it and information about that property. None of that was available online. Whereas in Clark County, I can go on Gizmo and I can see who owns what property and what LLC they are and whether their fictitious firm name was filed, and find out all this stuff just in a few clicks. Which I like having that availability for that part, but especially commercial, but I think it could be misused. So just having more clarity would be helpful.
This is Stacy for the record. I totally agree in making it more clear. Because one thing, it's like the government transparency is to hold government accountable, not its citizens. So I think anything to do, I mean, for public release, it should be the actions of the public officials, because we're ready for that scrutiny anyway. Anything that affects the private individual should remain private. It's not public. It's the whole part of this is to make officials accountable to the people, not just get information out on all of our citizens. So I think it's a very fine line, and definitely everything that government should do should be able for anyone to come look at and open for free. But when it's not related to an actual official, when it's not related to an actual government process, I don't see where anything like that should be transparent. If someone's looking for marketing data, they can go search the record and pull it off county records and that kind of stuff themselves. I don't agree unless it's government related, it should be public record.
This is Matt Christian. I just think that's such a good point, Stacy. Getting back to the basics of why there is a Public Records Act, it's to make sure that the public knows what its government is doing. It's to ensure government accountability. And I would just go back to a couple of these articles that I submitted. It's hard to really understand what body worn camera of a drunken juvenile making a fool of themselves, what that really shows about the government and the government's behavior. It's really more about the behavior of an individual. So I just think that's a really good point. The basics are designed to show the public that their government is working for them, that it's not wasting money, it's not doing fraudulent things. But a lot of these records, when we're talking about privacy, it doesn't seem to be that the request is about uncovering or exploring or knowing what the government is doing. It's more about what the individual is doing.
This has been, I think, looking at it as whether the public has an interest in one drunk teenage girl yelling at the police, as the example in the article you sent around talked about, isn't the issue. The issue is, should the public not have access to body-worn camera at all? Because occasionally YouTube sites are going to be able to get a hold of a drunk teenage girl yelling at the police. And I mean, I, for one, don't think that we should shut down all access to something like body-worn camera, simply because there will occasionally be embarrassing moments for individuals. I mean, in fact, I would think law enforcement would like the fact that the possible shame people might feel in having these things become public is part of what keeps people from committing crimes to begin with. But either way, again, I think the question isn't, are there a few individual instances where maybe all of us would rather it weren't public? Is it the tail wagging the dog to say we're simply going to shut down access to those things?
Yeah, this is Matt Christian. I'm definitely not suggesting that body-worn camera be completely shut down. But that example you gave is actually really, really interesting, because the sheriff, or really any police chief, it would be very wrong to come out and say, we want to give you all this body-worn camera so that we can shame you into not committing crimes. That really gets right back to the article that I sent about mugshots, right? The rogues galleries. And this new case that came out from the Ninth Circuit, Houston versus Maricopa County. The police or any government agency, our role is not to punish you as a private individual. That, as the Ninth Circuit has told us, that would actually be unconstitutional. If we were providing mugshots or we were providing body-worn camera for no other reason, no legitimate law enforcement purpose whatsoever, but the only reason is to try to prevent other people in the future from committing crimes, because if they do, their mugshot is going to be in the RJ or on Channel 8 News. We've been told that's a violation of the 14th Amendment.
This has been, again, the issue isn't whether you should be turning over, or excuse me, law enforcement should be turning over body cam footage that it decides it wants to turn over for the sake of shaming people, but whether the public should have the right to access that information, even if the person involved feels the stigma of public knowledge of their criminal activity.
It's Colleen McCarty for the record. I'm just looking at the statute, and it does talk about The purpose of the chapter is to foster democratic principles by providing members of the public with prompt access to inspect, copy, or receive a copy of public books and records to the extent permitted by law. So the idea is that records created by our government are supposed to be accessible to the people. I think when we start injecting morality and sort of personal opinions about what should be done and what shouldn't be done, it's gets to be a very slippery slope because one person's opinion is going to differ from another's. The idea is we're supposed to be able to see the records that are made and kept by our government. And I think that is the overarching principle that we're supposed to be acting with. And again, it all comes down to context too. When we look at, well, should property information be publicly available? Well, maybe you want to look to see who owns the house because you want to make an offer on it. Maybe you want to look to see how many investors have bought up properties in Clark County to determine whether or not we need to make some policy changes, right? Having access to those records can have a myriad of reasons behind it. And so I think when we try to narrow down who should have access to what and why, that's not what our law says. There are specific carve-outs, but the overarching presumption is everything's supposed to be public.
This is Stacy Lundberg. I don't think that anyone that interacts with a public official or a policeman or judge or something is giving up their privacy rights. So when they're acting and come into contact with a police officer, what service does that give to the overall people other than what the shaming thing? I mean, everyone's going to make mistakes. You got to be pretty high on your horse to think that someday you might not get pulled over. But I think it's very important to protect the privacy of our citizens. And just because they've interacted with a public official and we've documented that does not make it public record.
So I'm going to give you an example. There's a horrible car accident on the freeway and a driver kills someone. And that driver's name becomes public and a journalist goes to look at their criminal history and finds that this driver has been cited however many times for speeding or drunk driving or what have you. And maybe they learn that that person was never punished in court because of however the traffic court is working at the time. And so there was no deterrent for that person not to get back into the car. And maybe that report leads to changes with respect to how the courts work or how traffic citations are given, right? There are a million different reasons why public records have a purpose, and disseminating that type of information can have a purpose. But even if it doesn't have a purpose, our law says it doesn't matter. If it's created by the government, it's supposed to be available except for the 597 carve-outs and except for a balancing of interest. And the balancing of interest exists to determine whether or not there is a public interest that is outweighed by the government's interest in retaining the record.
And the victims get to see it on TV and hear about it over and over and over again. So there's two sides to every story.
Yeah, I think this is Matt Christian. I think Colleen has a good example. That would be something that the media would be able to receive if someone is arrested and they had been arrested before. The media, at least here in Nevada, is entitled to know that. Stacy's right, though. It could re-victimize people to see their loved one in that car wreck. So I mean, that is something that we are thinking about, is victims. And in your example, I just want to make sure it's clear from our last presentation last time, there can be constitutional considerations there too, right? If someone is DUI and they kill somebody in a car crash and there's so much media attention because they've been convicted before, it really could affect their ability to have a fair trial. So those are legitimate things that we think about. We want that person to be convicted as a police department. We don't want to jeopardize that prosecution. And so it's not that we're trying to hide the fact that they've been convicted or the details, but we want to make sure that their prosecution isn't, that there's no glitches with it. And the information will, it will eventually come out, right? If there was something that was made confidential, maybe it would come out during the ordinary course of the criminal prosecution. But I think these are things that we can have a little bit further definition to. In the example you gave, I don't think it's controversial at all that the media would be entitled to know the criminal history of that individual. We're talking more about the video footage or the names of the witnesses or their addresses, things like that, that it's not clear to us what we should do with that kind of information in a case like that.
I think too, it's important that we recognize that not every witness has the same opinion about what happens with their information. And not every victim believes that no record about what happened to their loved one should ever be released. I think when we start making broad assumptions based on a classification of a person, we may get it right, we may not. That's why it's really not up for us to be deciding those kinds of things.
This has been, I think it's certainly worth noting that over the last several decades, while there's been a vast expansion of the amount of information that we can get and that we are provided, and talking about, like victims coming forward, and you don't want to stigmatize them and afraid that other victims won't come forward. It seems pretty clear that over the last several decades, as there's been a massive expansion of coverage of, for instance, sex crimes, the number of sexual assaults that are out there, the coverage of it, us hearing the names and seeing the names of victims. And yet I think there has been nevertheless a vast expansion over the years of sexual assault victims coming forward. And I think it has both helped victims to come forward and help identify the extent to which the system dreadfully treated those victims over the years. And I think the expanded coverage of it over the decades has not in any way caused a stigma effect that has kept more people from coming in, but rather has had the opposite effect and has increased the number of people coming forward.
This is Matt Morris. I don't want to pivot too much unless we're done, but this kind of goes back to a comment earlier, Leslie, that you made, and it came up in I think the last presentation around concerns about disclosing a record and then liability, right? And I think 239 at least is intended to provide some immunity there, and I think that came up briefly during the presentation, and the comment was that that's limited. 239.12, that's a limited provision of immunity. It doesn't perhaps go as far as it needs to. I don't know if that's maybe not to skip forward in the agenda, that might be a topic for a meeting to have someone really delineate where that immunity stops. Because if there is a legitimate concern from the disclosing entity that there could be liability for responding to a public records request, that's an area of shared interest, right? From the requester, I don't want to submit a records request and then have the person who's got to respond to it be afraid that they're going to get sued for disclosing, right? For doing what I'm asking them to do. So if there is, now I think 239.12 is pretty clear, but that there's immunity from damages for a good faith disclosure or for a good faith decision not to disclose. But if there's limits there that we could clarify, then I think we should look at that too.
Yeah, are there pieces to that you all think are insufficient?
This is Matt Christian. To the best of my knowledge, it's never been litigated what it means to act in good faith. So from the perspective of someone that advises the government, what I have to look at is it does provide some immunity, but it's not clear how broad it is. So it would be very, very easy to be sued and for the plaintiff to allege that the disclosure was not made in good faith. So now we're still in litigation, and now we still have to defend the decision to disclose that record, and it's completely unknown whether we would it would be found that we were acting in good faith. It would depend on the clarity of the law. And I guess the less clear it is, maybe the better it is to argue that we're acting in good faith. But that's not a solution. We want to know what to do. So I guess that would be my response to the good faith immunity.
Please.
This is Leslie Nino Piero. One other quick point I'd make about that is that I'm as general counsel of the Attorney General's office, I'm also concerned about not just an individual's liability, a public official or employee, but also the entity, the agency's potential exposure. And that statute does not say anything about the entity's potential. As a person who manages many settlements and the tort fund for the state, that's something that is exposure for the state, and potential financial liability does not go away simply because a person would be immune.
It says the employer is also immune.
Thanks for the clarification, Carmen. I appreciate that. My progressives are not so progressive right now.
But my point is, if there's some language that we want to work on with that, I think we're pretty much all in agreement that that's something we could get to. So
my one other comment, this is Matt Christian, my one other comment on that would be kind of going back to our earlier discussion. It is, if it's so hard for a requester to file a lawsuit because it's so expensive and so complex, what are the chances that someone whose privacy rights have been violated would actually sue the government? So, we're trying to protect people's privacy interests. We don't want to violate their privacy interests. The police are in the business of helping victims. That's what we talk about every day at Metro. We're trying to help the community. We're not trying to harm. We're not trying to re-victimize. So it's maybe that's why there's been no litigation, because who would have the resources to sue over the disclosure of their private information? It's up to us to protect it.
Leslie Nino Piero, two more quick points. I mentioned earlier, I'm constantly thinking about whether there would be a chilling effect from a victim. I'm also thinking about whether or not information that we disclose could be fuel for retaliation. And that's just one more consideration in the privacy balancing test for me.
All right, thank you.
Leslie Nino Piero, again, I want to make one quick administrative just reminder that LCB has emphasized that we have a hard stop at 4:30. And of course, we'll need time for public comment as well. So just a reminder.
Thank you for that. We'll try to get through everything we can by I would say 4:10 to 4:15 to give us time to get through any public comment. Were there any comments on 4.3 criteria for granting or denying access.
Just to clarify, the statute says, again, the titles were shortened on a couple of these just to fit on the page, but to identify situations in which access to public records should be granted or denied.
This has been, it seems like we've been talking about a lot of that as we've been going along. I certainly think it's something we need to discuss. I think we already have been, and confident we continue to. Not that I'm suggesting trying to cut anybody off.
No, thanks. Thanks, Ben. That's a good point. Why don't we just kind of move through these, and, you know, anything that we can open up, we will. Penalties for delayed or incomplete responses. Does anyone want to open up the discussion on that, and how we might want to make some recommendations in that area?
Leslie Nino Piro for the record. I understand the desire for accountability measures. I just would say that monetary penalties are probably not the best way to go about that. And I would think a little bit more along the lines perhaps of like training requirements, certifications for handling public records, something along those lines is what we should be thinking about more than just monetary fines, because at the end of the day, it causes the problem that Stacy alluded to, which is just, you know, we're then putting this on the backs of the citizens because it's public money that we're using for this. So I think some type of training requirements maybe would be considered a better way and actually get to the problem, which is people not understanding how to properly respond to public records requests.
This is Stacy Lambert for the record. Very well said. Thank you.
This is Matt Christian. I would just add that the statute already has monetary penalties in it, and they're pretty harsh. We talked about that last time. It's a never-ending concern that when we deny a public records request, that if we're sued, we're going to end up owing attorney's fees if we don't prevail. It's a very severe penalty. And it was a couple of sessions ago that additional penalties were added that escalate already. So I'm not really sure if our transparency friends want to make it even more monetarily difficult on the public agency or not. But I can tell you, like I said last time, that those penalties are serious in my view, and they're absolutely under consideration at all times.
Leslie Nino Piro, I would, to add to that, the availability of attorney's fees is the biggest concern from an entity standpoint, because those add up real quick.
I think the concern is, and certainly what I saw as both a reporter and now as someone who represents reporters, the instance where somebody gets a public record within 5 days is now entirely the exception and not the rule. Now what you get is you get, from at least the larger agencies, you get an automatic email from some sort of a system that says, we got your request, we'll get back to you. And then maybe a couple weeks later, you get another email that says, we'll provide your information by such and such a date. And then the date comes and you get another email that says, now your date is this. And then the date comes and you get another email that says, now your date is this. And it goes on and it goes on and it goes on. I've litigated many cases where records are withheld for months and months and months. And sometimes it's not even a function of we think the record's confidential and we're fighting about the contents. It's simply, they're just not being produced. So we are looking for solutions to that. And maybe it's training. I would be interested to know who would do that training. What would that training involve? Could we have that training for everyone who works in the public record space? If we could all agree on what that training should say. So that's the discussion around monetary penalties. Is we have gotten so far afield of what public records responses used to look like, due in large part to automation. And I know the automation has a wonderful, is wonderful to help reduce the staff time that's needed, but at the same time, it's also adding significant delays to public records responses, at least what my clients are seeing.
Leslie Nino Piero, I think you're absolutely right. Their requests are taking longer to get fulfilled, but I don't see, because the statute itself, that 5-day requirements is the same that it's been, correct me if I'm wrong, I believe that's the same that it's been since the MPRA was put into place. But the way that government agencies function has changed dramatically. And the amount of, I've had conversations with the state CIO, and the sheer amount of data that government agencies now hold. If you think about going back even 20, 30 years, there wasn't email. Terabytes and terabytes of information to sift through. There wasn't all kinds of different voicemail messages that are held. There wasn't body cam information that was held. So I understand what you're saying. The expectation has stayed the same, that records will be available in 5 days, but there hasn't been any sort of acknowledgement that the way that we function, the amount of data that we have to go through is exponentially larger. So would you, if you're concerned about not having more certain dates, would you be interested in proposing some type of different timing structure because I agree with you, the 5 days is not happening in most instances, but also it's just not possible. It's just not possible for us to search and confirm that we have a fulsome gathering of records, and then to have it go through, especially with multiple departments, multiple databases, and then to have review of that information and redaction of that information and go through a production process. It is not feasible in many, many cases for that to happen within 5 days.
I think that it largely depends on what is being asked for. And the Public Records Act was created with the idea that you could go down to the Attorney General's office and ask for a record, and they would hand it to you. And there are still many records requests that are frankly very simple and don't require the logistics that you're talking about, that are not being fulfilled in any sort of reasonable time frame. So what do we do about that?
Respectfully, Colleen, I would push back on your point that they are simple. I think it's difficult if you have not worked within our office or any other to make that sort of a broad generalization that any request is just simple. Why don't you just give it to me right now? I'll sit here in the lobby until it comes.
I'll give you an example. If I ask you for the Attorney General's phone list that does not contain any personal information, I'm not asking for cell phone numbers, I'm asking for what is your government extension? I want the phone list. That's not a difficult request, would you agree?
So number one, I'd have to find out. I don't know that I even have a copy of that on my phone or on my laptop. It's constantly updated. So I'd be finding if the record is the most current record. And then also if it is an agency-wide, we have some investigators who operate undercover. So I would need to go and determine who operates undercover, and if I need to redact that information. There are considerations that you may not think about prior to, and that we're constantly making sure that we are not exposing information that is not properly within the public sphere.
So how long do you think is a reasonable amount of time for like a request like that?
Well, let me start with another question. Would you generally say that it's most appropriate to handle requests in the order in which they are received?
Sure. But
Okay.
also I think if there are things that can be triaged and you can get the simple thing out the door, there should be some mechanism to look at that as well.
Okay, so if I have Ben asked me for a very complex request and my people are working on it for over a month, you want me to stop what they're doing, stop their processes, and because your request, so you want me to place a value judgment on whether or not your request should be fulfilled before Ben's?
So I'm back to my original premise, which is what do we do about the delays?
I 100%
Right?
agree with
What
you.
do we do about the delays?
I 100% agree. And in my view, many of the delays are caused by a lack of proper technology and staffing. And so hopefully with all the data we collect and the recommendations that we put forward, we're going to give the legislature a roadmap for how we improve, and it will have the intended effect of reducing delay.
But since our,
This is Matt Christian.
go ahead, Matt.
Oh, I was just going to ask real quick, is there a proposal for adding penalties from the transparency side? Or,
Not at
there's-
this time.
okay.
All right, since our time is becoming a little short, rather than go through these, maybe we just open it up throughout the rest of this. Are there any specific sections or proposals in this template that anyone wants to bring up? We've had a really good discussion on a lot of points, and I think we'll have more information and solidifying things in our next meeting or two. But while we have everyone together, are there any sections that anybody wants to bring out and focus on right now?
Kaylee, work for the record.
This is Brittany Walker.
Sorry, Brittany. Go ahead.
Oh, thanks, Kaylee. I just wanted to point out for 4.5 and criminal investigations was struck. But that is specifically in AB 128 to look at. So I would like to unstrike that from the title.
Oh, that's all I was going to comment to. Thanks, Brittany.
And this is Matt Christian. I guess I would just point out that the additions of 4.8 through 5.2 are they're beyond the bill. I think this report was kind of structured after the bill itself. So I'm not saying that, for instance, 4.8 wouldn't fit into some other category, but I would prefer to keep the structure identical to the statute.
This
I
is
agree with Matt.
I don't disagree either. I just would point out, I think the language of AB 128 is sort of illustrative, and it says including without limitation. So I I agree. I think it is easier to follow and sort of digest when we stick to 128 and what's actually called out in the bill. But I will also just, on the meeting minutes on 5.2, having now submitted several requests for public meeting minutes that weren't posted online, and then you got the 5-day standard, well, we'll evaluate your request to see if you're requesting a public record, et cetera. I mean, it's one of the, I think the horror stories. If we could address it somewhere, maybe it doesn't need its own 5.2, but if we could put that somewhere in the report, it'd be great, be helpful.
Thanks, Matt. And I'd agree with that. This is Josh Hicks speaking. I recognize those are a bit beyond the specific directives of the bill, but it also seems like an opportunity to maybe make some recommendations. To me, both 5.1 and 5.2, they don't really get into the issue of is something a public record or is it not a public record. It's just simply about making what would be public records more easily accessible to the public without having to go through a public records request, without having to utilize the resources of governmental agencies, and just being more efficient that way, which I think is consistent with the spirit of the legislation.
This is Stacy Lindberg. I agree with that also. I think it's very important for the public to have full access to those online. I totally agree with that. And it would help with the requests. So if everyone had access to those. So I do agree with those.
Are there other aspects of the template or concepts that we want to unpack a little bit more today? Open forum, so please bring it up if you'd like to.
This is Leslie Nino Puro. I'm a little bit confused by 5.1. Can I get a Reader's Digest nutshell explanation? Is that what you were just talking about, Matt?
Yeah, Leslie, this is Josh. I'll give you my thoughts, and anyone else can chime in too. Again, the thought was, many agencies, particularly state agencies, in my experience, local governments tend to be pretty good about posting everything online, and it's easily searchable. State agencies are a bit more of a mixed bag, in my experience. Sometimes you can find opinions relatively easily from an agency or a board or a decision. Sometimes you can't, and you have to make a public records request to go through it. So it was really about uniformity in that, and records, particularly decisions that would be of interest to the public, particularly members of the public who wanted to see how other members of the public are treated by a particular agency or board or commission under similar circumstances, so that they can obtain those records that would be public anyways without the burden of going through a public records request. So that was the concept there.
Thank you. That's very helpful.
Okay, are there any other substantive comments? I know agenda items 6, I think we've been talking a lot about that in our discussions here, but I want to make sure before we move on to picking our next, or talking about our next meeting date and topics, that we have a full opportunity to identify any other substantive issues.
I'm just wondering, do we want to entertain any like subcommittees to start writing more of this before we meet next? I don't know, it's just a thought, because there's a lot here and there's still a lot for us to put on paper before we meet again, or I guess before our meetings run out. I don't know if there's an appetite for that.
I would just say that subcommittees, again, formal subcommittees appointed for, by the body are subject to open meeting law. So just if we have any subcommittees, we do need to have those meet in open meeting.
And at this point, we only have 2 weeks to our next meeting, correct?
That's right.
Correct. I will say, I think any of us can put forward, just like you all did today, the transparency side posed the recommendations, and I think one member can do that.
Yeah, I think we're going to have, according to my notes, we'll likely have a list of the exemptions to the Public Records Act. I think Matt Christian, Leslie Nino Piro had a list. They were going to start putting that together. I think we were going to have a fee schedule that Colleen was going to assemble and provide to us as well. So to Brittany's point, I agree. I think maybe the best way is, we had a robust discussion on a lot of topics today. There's a lot to think about in the next 2 weeks. But to the extent individual members can come to the next meeting really prepared with solid recommendations to put on the table, or maybe even draft language for a bill, so that we can dive into it a little less conceptually and a little more technically, I think would be a good use of our time if the task force members are able to do that.
Brittany Walker here for the record. I'm happy to work on the report. I do want to just point out for a bill, we don't have a bill draft as a task force. Of course, we could ask a legislator to sponsor it if we wanted to do that, but I'm just making sure that's clear that we know we don't have a bill and the task is the report.
Yeah, thank you, Brittany. I appreciate that clarification. I wasn't thinking of her giving a draft bill. I was just thinking if there were certain areas of Chapter 239 that we maybe had language for them the legislature to consider in a future bill, that might be helpful to them. Okay, should we move on to our topics, the next meeting dates? Does anyone else have anything else? Stacy, did you have something?
Oh, I was just going to say, I think that's really important, and appreciate you bringing that to us, because it's going to be, it will help us get into the meat of it. It's like, this is what it says now, and this is what we propose. I think that would be very, very informative and keep us on task and in a good direction. So I think that's a great request of us. Find something you're passionate about and see how you'd like to change it and submit it.
Thanks, Stacy. Any other comments, or are we ready to move on to talking about our next meeting? Okay, let's discuss our next meeting. I think we likely leave the same agenda items we had today, except we don't need another discussion on the Joint Interim Standing Committee. It sounds like there might be two potential presentations at that one. Mr. Christian mentioned one, and Ms. McCarty mentioned one as well. So if those presenters are interested, I'd ask you to lock that down as quickly as you can, so we know that. And please ask them to prepare and present any presentation materials in advance so we can post them. Did anyone have anything else they wanted to think about adding to our next agenda?
We also heard from, Kaylee, work for the record, we also heard from the State Bar of Public Lawyers and from NDOT that they could both be available for a presentation to the committee as well.
Okay, thoughts from the task force about adding those two presenters to our next meeting?
Leslie Nino Piero, if they are focusing on, I think the presentations that we've had to date have talked about the overbroad requests and a couple of other topics. If these presentations are focused on fees, that would be a really helpful, like some of the information that we're looking to gather from some of the agencies, that could be helpful, like what technology is used. I'd be happy to work with whoever reached out to maybe facilitate that survey and try and gather some more information. But I do think that presentations could be helpful.
This is Brittany Walker. I would agree, and to have possibly best practices across the nation, if one of those entities has that information, since we've been requested by the legislature for that.
Okay, and I suppose also any those agencies or any other interested parties can always submit written comments as well, which are also helpful to us. I know we've had some really, I think, useful ones that have been put in there. Okay, well, if we have interested presenters, whoever has been in contact with them, just check their availability. I have us down for August 5th at 9 a.m. for our next meeting. Is that what everyone else has too?
Yes.
Okay.
Are we in the same room? Does anyone know?
That's what I was going to ask, if anyone knows what our venue is going to be.
Leslie Nino Piero. So LCB was kind enough to agree to host us again. So it'll be similar. I'm not sure if it's the exact same room, but it will be here in the hearing rooms and then also in Carson City. So it'll essentially be the same setup as today.
Okay, that sounds great. Does that work for everybody? I assume it does.
Yes.
Okay, great. Then August 5th, 9 a.m. will be our next meeting. Substantially the same agenda. We'll likely have a few presentations, and we'll be asking task force members to bring back the information that they've said they'd be getting, and also come forward with specific recommendations or thoughts so that we can put a little more solidity into our report as we kind of come down the home stretch here. Does that sound good to everybody?
Yeah.
Yes. And Josh, can we also talk about September's meeting?
Yeah, please. I need to get
Yeah,
I need to talk about that as well.
Thank you. Did we save a date for that one? I forget.
So we had talked about having it at my law firm, which we can do. And we had floated the 9th or the 10th. My facilities are only available on the 10th. So if that works for everybody, that's fine. I will point out that these facilities are wonderful and might be better suited for what we're doing. if they could possibly be available, given that there are so many rooms here. But if not, we can have it at Ballard, and we're happy to host.
For what it's worth, this has been September 9th. If that's the only date that works, I can make it work, but I have some other items there that would be a problem. And so September 10th, whether we're at Ballard, where it would have to be September 10th, or we're here where perhaps we might have an option. If it works for people's schedule, that would be much appreciated, but I certainly understand if it simply cannot, but if it could, that would be of great help to me.
I also have a unmovable conflict on September 9th. So I'll help you out there, and would be, I can ask. I don't, the LCB is a separate entity. I can ask if they have availability.
That would be much appreciated. And if they don't, then we can do it at Ballard's Bar. We just don't have as much room there as we have here.
But the coffee is probably better.
The coffee is excellent.
Not a coffee drinker.
There is no coffee here, so.
We have lots of snacks and sodas.
Okay, so shall we put a placeholder on September 10th at 9 a.m. and Ms. Nino Piro will check on the availability of these rooms, and if not, our fallback will be, at least in Vegas, will be Ms. McCarty's office at Ballard's Bar. And then we'll figure out a Northern Nevada location as well.
And I apologize. I had the 8th and 9th blocked on my calendar. I will not be present if it is on the 10th.
How is the 8th for everybody?
This is Leslie Nino Piro. I'll be traveling that week. So even the 10th is a bit of a stretch, but the 8th I'll be in flight most of the day.
Okay, well, why don't we proceed with the 6th and the 10th of September, and then we can, on our August 6th meeting, we can kind of revisit and see if schedules have changed for anybody. And
You mean August 5?
I'm sorry, August 5. Yes, thank you. So
Yep.
Let's plan on September 10th at 9 a.m. And during our August 5 meeting, at the conclusion of that, we'll rediscuss the September meeting and see if schedules have changed around and if that would work, if other dates would work better. But we'll plan on September 10th. Does that work for everybody?
Yes.
Okay, anything else, topics or next meeting dates from the task force?
I was just going to mention I'd be happy to make the agenda for the next meeting.
Consider that assigned. Thank you.
All right.
Okay, anything else on that topic? If not, we'll go to public comment. Any public comment in Carson City? We do have one speaker here, so please state your name for the record and proceed.
Thank you, Chair Hicks, Vice Chair Work. It's good to see you both. And thank you to the members of the committee. Thanks for your service to the state of Nevada. Been watching these proceedings. I had a couple of comments and questions for the consideration of the committee. In the statute,
Could you please state your name?
I'm
sir?
so sorry. My name is, for the record, is Tyson Falk. F as in Frank, ALK is my last name. I'm a Nevada citizen here appearing on behalf of myself. A couple questions and comments. In Nevada statute today, the only temporal constraint that we have is that 5 days response deadline. They can pass that off as long as they will respond within the 5 days and say, here's the earliest reasonable date of which we think we can comply. There's no temporal constraint on the amount of times that they can say we failed to meet that reasonable delay that we projected over and over and over again. that leads to a potential and a real results in effect that you could have serial delay, really denial in so many words. Who's there to check sort of whether that's reasonable? Because that's ultimately the reasonability is judged by the agency that's been receiving the public request. So that, I think that that's something that the committee should consider, whether it's, the ombudsman or some ADR type of solution here. The Attorney General's office, their representative here, it's talked about that they are the counsel for other agencies. And well, that's absolutely true, but there's records within their custodianship at the time. But when I believe that Ms. Pirro said that, well, we defer to the other agencies. Okay, but also that you're their counsel. So how does that match in that you just defer to them? Do you give a requester directions on to go to that agency that you have to follow those procedures? I think that sort of splits the baby, and it really isn't fair in the guise of public responsiveness per the policy of Nevada Public Records Act. And then a couple other things. There was a comment about the provision or the providing of attorney fees in response to litigation, that's a real fear and that's a real risk to an agency. Okay, what if we are now forcing a pro se person to file litigation because, well, they haven't got a response within a reasonable time? There is no attorney fees provided in that case. So how do you match that's the fears, the litigation on behalf of that? And lastly, I think that there's an idea of what's an overly broad sort of request. What does that really mean in that does it deal with multiple topics, multiple data portals, different custodians? And also the claims that, well, this might be part of litigation, either prior or even contemplated. Does that have an impact on whether these are delayed or whether they're fulfilled? I think that no matter what that answer is, you can't justify the potential of it being used as litigation as also a justification for delay. I think that there has to be a delineation between the two. And so for that, I thank you again for your time, and thanks to the members of the committee for serving on here, and thank you.
Thank you, Mr. Falk. Good to see you. That is our only public comment in Carson City. Is there any public comment in Las Vegas?
Matt Christian, no, there's no one here.
Thank you. Do we have any public comment online or on the phone?
If you'd like to participate in public comment, please press *9 or raise hand in the Zoom window to take your place in the queue.
Jeff Church, are you ready for me? I can't hear you.
We can hear you. Go ahead.
Okay, thank you very much. For the record, Jeff Church, I run RenoTaxRevolt.com. Very frustrating today. I really don't think anybody on this board's committee is representing the users such as myself. If there was, there'd be penalties. Again, pro per people that are representing themselves, they don't get attorney fees, but you can delay as much as you want. And that's what consistently happens. If you remember the last meeting, many people, they're waiting 18 to 24 months. These are not adjudicated in weeks or months, it's years and at great cost. And the person that spoke out against the ombudsman being too costly, that's just not credible. I'm sorry, but it's not credible. We need an ombudsman, a hearing officer, something short of judicial review initially to resolve this. This just cannot go on this way. And I don't have any faith that anything's going to come out of this committee. I'm very disappointed, but we have to do something. And to say, oh, they're too expensive. The cost of an ombudsman and an ombudsman office pales in comparison to just my one case that Mr. Bob Conrad mentioned. Again, it lasted 2 years. I was also appalled at the comment about commercial activity and saying that the news media, they were commercial. Come on, folks. They are digging for the facts. Bob Conrad, this is Reno. He is a watchdog over public documents, and he's not, yes, he maybe is a commercial business, but to somehow say that because he's a news media commercial business, he has to pay a fee. All you have to do is simply find somebody in your family or your friend or somebody to file it instead. That's just got to be a non-starter. I would admit that body cameras need to be addressed by the legislature separate from the other things. And the one thing that really got me, at some point there was a comment about, well, how do other states do it? We should look into that. That should have been done on day one. Then it kind of died. I never heard any more on that. Absolutely, we need to know how other states do it and what's successful and what's not. And I actually submitted public comment a number of meetings ago on that very issue, mentioning some specific states, and you know, I didn't go into great detail, but I mentioned it. Maybe UNR can do it, maybe UNLV, SCLU. There's got to be some group out there maybe that could do it for you on short notice. And I also I had a phone call from Mr. Joe Penicaro. He's been trying to call in, and your call-in number is not working, and he's not tech savvy on the computer. So we do have an ongoing issue, and he said this has happened to him over and over at these meetings where the call-in number isn't working. So again, you can blame it. Oh, technology, OML doesn't count. Technology, we don't care. Again, I just am so frustrated, and I don't expect anything to come out of this, but the present system is not working. We have time. I have two pending. I want a contract, simple little contract from Washoe County, and weeks and weeks, and I don't get it. There's nothing confidential about a contract with another agency, and you get the standard response like the last speaker mentioned.
Mr. Church, you're at 3 minutes. If you
and
could wrap up,
nobody's looking
please.
out for me. Thank you. Thank you.
Thank you. Do we have any other comments online or on the phone?
Yes. Again, my name is Kathleen Light. I was here last speaking about my rape by the former Deputy Insurance Commissioner and the lack of action by the Attorney General's office for what now appears to be, to me, financial reasons that would have directly impacted the Attorney General's office itself. Apparently, it is of note that my rapist did have a non-disparagement both ways in his separation agreement done under Aaron Ford's authority. It says it right there. I'll send it with my comments. Some of this body seems to be building an argument that people like me profit from public records and the real victims suffer because of us. So let's set the record straight. I've never made a penny from my website. It cost me money. It is the only meaningful thing I've been able to build from what happened to me. About 33 followers on Twitter. I'm persistent because I'm trying to get someone's attention. Last time, I could not get the Attorney General's representative on this body to look at me while I spoke. My rapist attended through Zoom, and before I reached home, my analyst showed visits from the state of Nevada ISP. This weekend was horrific. My website and devices appeared to be hacked. Unknown entities communicated with me through ChatGPT, one claiming to be the FBI, and then a separate entity that told me that I was being arrested for federal crimes. But alas, the FBI side told me that it was okay. It was going to be okay. I wasn't getting arrested. The Attorney General and my rapist were. I cannot verify who was behind those messages, but I wish to God I were making them up. I did take down my website because I no longer believed it was safe. Tomorrow morning, I must appear in Vermont court seeking a protection order from my rapist. I will, by the way, note that Vermont turns around their public records in about 5 days and has a database, including a separate database for the largest regulatory failure in the history of that state. Of course, my rapist was under investigation for that when he was hired by Nevada. And I just got off the phone with the real FBI. I live in a world where my state government will not protect me. Then it refuses to give me the records explaining why. But alas, the state seems to feel I'm not entitled to protection from retaliation. As a victim, I myself have submitted records to this body that are embarrassing to me and discuss and disclose my body. I don't care. I'm more concerned about a man who has raped multiple women being free as our government refuses to charge him because it was potentially worth tens of millions of dollars. I'm trying to make a change in the world. Instead, the institutions that failed me now appear prepared to treat my persistence as the problem. So I'll not end with another argument. I'll end with 13 seconds of the evidence that the state already possessed when it decided not to prosecute.
Thank you, Ms. Light. Do we have any other public comment online or on the phone?
There are no more callers wishing to participate at this time.
Okay, thank you. With that, we are at the final agenda item, adjournment. I'd look for a motion and a second to adjourn.
This has been so moved.
Thank you. Do we have a
Colleen
second?
McCarty, second.
Thank you. All in favor of adjournment, please say aye.
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 Any
Aye.
opposed?
Aye.
Motion passes. We are adjourned. Thank you, everybody, and we'll see you on August 5th.